Good morning, everyone, and welcome to the Open Meeting Law Potpourri webinar with the Data Practices Office. Thank you for joining us this morning. If you're not aware of our office, but you probably are if you're joining the webinar, just wanted to go over what our office does. And so we are the Data Practices Office. We are a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and government. So if you have a question about these laws, please feel free to reach out to us at any time. We also assist the Commissioner of Administration with issuing advisory opinions, and we do provide legislative assistance and training. This PowerPoint is posted on our website, so if you aren't able to download a copy today, it is on the page where you registered. We do also record our webinars, so if you miss part of today's discussion or want to go back and watch it again or find one of our prior series, those are posted on the Data Practices Office YouTube page. You can find more information at the URL listed on this slide, and we'll have another slide later with more information on accessing those resources at the end of the webinar. If you'd like to download a copy of the PowerPoint right now, I will share the file for you to download and save to your computer. A pop-up window will appear, and then you can select the file and download it to your device. Give me 1 second. Okay, so the file should be up and you should be able to download it at the moment. Again, if you aren't able to download it, it is available on the web page where you registered earlier today. Okay, so today's webinar is going to focus on the open meeting law. We'll start with a refresher about the general requirements of the law, and then we'll highlight questions that we've received in the past several months about the law. As always, we'll leave some time for a Q&A session at the end of the webinar. So please feel free to send in your questions as you think of them using the Q&A panel on your screen. When you send those questions in, be sure to choose all panelists when you send your questions so we can all be sure to see them. There's 3 of us on the call here or on the webinar, and if you select all panelists, then at least one of us will see them. You can start sending them now, those questions now, or you can wait until the end of the presentation. Okay, let's start with a refresher of the open meeting law's requirements before we turn to some of the questions we've recently been seeing. So, the open meeting law is contained in Chapter 13D of Minnesota statutes, which states that all meetings of public bodies must be open to the public, with limited exceptions. It's a fairly short law that focuses on technical requirements, and it leaves some room for interpretation. As a result, the Supreme Court has often stepped in to clarify and sometimes complicate the analysis of the law. That said, the Supreme Court has identified 3 primary policy objectives behind the open meeting law, including prohibiting official public body business from being conducted in secret meetings, to help assure the public is informed about the workings of a public body, and to ensure that members of the public have an opportunity to express their views to the public body. On this last point, though, the open meeting law does not contain any requirement that public bodies provide time during its meetings for public comment. Okay, the open meeting law does not define what is considered a meeting that is subject to the requirements of Chapter 13D. However, the Minnesota Supreme Court has stepped in and provided the quorum rule to define when a meeting of a public body is occurring. There's 2 parts to this rule to determine when a meeting is subject to the open meeting law. First, there must be a gathering of a quorum or more of the full public body or a quorum of the body's committees, subcommittees, etc. And second, the quorum of members discuss, decide, or receive information as a group on issues relating to its official business. If both of these factors are occurring, then you have a meeting that's subject to the requirements of the open meeting law. Now that we know when the open meeting law applies, let's look at a few different situations when the law does not apply. So, the open meeting law does not apply to gatherings where there are fewer than a quorum of public body members. For example, if two school board members of a 7-member school board are discussing an issue with a constituent, it's not a meeting subject to the law. Next, the Supreme Court has determined that the open meeting law does not apply to chants or social gatherings. However, the members of the public body will want to ensure that they are not discussing public business at these events. Lastly, there are both Attorney General and Commissioner of Administration advisory opinions that state the open meeting law does not apply to trainings or team building events so long as the trainings focus on general issues. These trainings should not include discussion of the body's official business, and these opinions note that if business will be discussed, then the open meeting law will likely apply. In addition to defining meetings, the Moberg court also noted the possibility that serial meetings could violate the open meeting law. So, serial meetings are meetings of groups of less than a quorum of public body members, and these meetings are conducted with the intent to avoid a public hearing or to fashion agreement on issues outside of public view. However, whether serial meetings have occurred in violation of the open meeting law depends on the specific circumstances of the situation, and it needs to be clear that the serial meetings were designed to avoid conducting business before the public. So any issues involving serial meetings do need to demonstrate that the public body members had the intent of avoiding open meetings. Okay, so we've covered what types of gatherings are considered meetings. So let's look at the different types of meetings that public bodies can hold and the required notices for these meetings. First, there are regularly scheduled meetings. These are your typical biweekly or monthly meetings planned out well in advance. Basically, these are the meetings you set your watch to. Next are special meetings, which are any extra meetings that a public body holds that don't appear on the schedule of regular meetings. Notably, a rescheduled regular meeting is considered a special meeting. Finally, there are emergency meetings. There's not a definition of what should be considered an emergency for the purposes of the open meeting law, which means we use the general understanding of an emergency. For practical purposes, an emergency meeting involves situations or issues that are so pressing that a public body cannot wait 3 days to provide notice for a special meeting. So let's dive into the meeting notice requirements for each type of these meetings. For regular meetings, a public body needs to keep a list of its regular meetings on file at its primary office location. There are some additional aspects to keep in mind, though. When there's a change in the date, time, or location of a regular meeting, then the public body needs to meet the special meeting notice requirements. Additionally, when members of local public bodies are attending a meeting by interactive technology, you do need to notice the location where those members are attending. More about that in just a little bit. Beyond the schedule of regular meetings, there's no additional requirements to provide any advanced notice. Of course, this doesn't prohibit public bodies from providing alerts or notices to the public about upcoming regular meetings, and that may help with transparency. However, it's not required that you actually go out and provide advanced notice of regular meetings. Next, we have special meetings, and as a reminder, these are any meetings that do not appear on the regular meeting schedule. So, for the requirements, at least 3 days in advance of the meeting, you must post a written notice of the special meeting on the principal bulletin board or usual meeting door. Additionally, you must provide notice to individuals who have made written requests to receive special meeting notices or publicize the notice in the official newspaper designated by the public body. The notice itself must include the date, time, and location, as well as the purpose of the special meeting. A few notes here. When calculating the 3 days, you do not count the day of the posting, but you can count the day of the meeting. For example, you can post on Friday for a meeting happening on Monday. You don't count Friday as part of those 3 days, but you do count Saturday, Sunday, and Monday. Additionally, special meetings are limited to addressing issues that are described in the meeting notice. so the notice needs to adequately describe all topics that will be discussed or acted upon. The Commissioner recently addressed this aspect in Advisory Opinion 22-009, so take a look at that opinion for further guidance. Lastly, emergency meeting notices. As I mentioned earlier, the open meeting law doesn't have a definition of an emergency. So when an emergency has occurred is left up to the discretion of the public body. That said, emergency meetings are appropriate only in exceptional circumstances, such as dealing with natural disasters. When it comes to noticing an emergency meeting, the public body needs to make a good faith effort to notify all media outlets that have requested notice, and the public body needs to include the subject of the emergency meeting. However, there's no requirement to post the notice on a bulletin board or a meeting room door. Also, the public body must create minutes that specifically document discussions of any issues not directly related to the emergency. There are a few additional notes for state public bodies when it comes to meeting notices. First, all the notice requirements we discussed only apply when the public body's enabling statute does not describe how the body must provide notice. When it comes to the schedule of regular meetings, a state public body can keep the schedule of its regular meetings on file at its primary office, or it can post the schedule on its website. Finally, a public body can meet the special and emergency meeting notice posting requirements by publishing the notice in the state register or on its website. Okay, we'll turn to closing meetings next. There are certainly times when public bodies discuss sensitive information, and the open meeting law permits closing meetings in certain circumstances. That said, public bodies can only close meetings when specifically required or permitted to do so by law, which we'll cover in a minute. When closing a meeting, the public body must provide a statement on the record that provides the legal authority to close the meeting and describe what will be discussed during the closed session. For example, a sufficient statement may be, this meeting will be closed as permitted by Section 13D.05, Subdivision 3A, to evaluate the performance of the city administrator. Additionally, closed sessions must be electronically recorded, and the recording must be retained for at least 3 years unless the law specifies otherwise. Notably, meetings closed for attorney-client privilege purposes do not need to be recorded. One final note before moving on. The open meeting law does not contain a general personnel exception to closed meetings. In other words, the discussion of employees' private personnel data or similar personnel issues cannot be used as the sole justification to close meetings. Okay, let's highlight the situations described in Section 13D.05, Subdivision 2, when a meeting must be closed. These situations include discussions that would identify alleged victims or mandated reporters of criminal sexual conduct, domestic abuse, or maltreatment of minors or vulnerable adults, discussions involving active criminal investigative data or internal affairs data related to allegations of police officer misconduct, discussions of not public educational data, discussions that involve not public medical data, welfare data, or mental health data, and any discussions involving an individual's health records. Lastly, meetings must be closed for preliminary consideration of allegations or charges against an individual subject to the body's authority. However, once a public body decides that discipline of any kind may be warranted, subsequent meetings about the issue must be open to the public. There are other situations when a public body has discretion to close a meeting, but it can also choose to keep the meeting open. These situations, which are described in sections 13D.03 and 13D.05 subdivision 3, include discussions about labor negotiation strategies, negotiation development, or to review labor negotiation proposals, discussions involving specific types of property transactions, and discussions involving or receiving security briefings or discussing specific types of sensitive security issues that could pose a danger to public safety or compromise security procedures. A public body can also close a meeting when it is evaluating the performance of an individual subject to its authority. However, the body needs to identify the individual prior to closing the meeting, and it must summarize the results of the evaluation at the next open meeting. The meeting must also be open at the request of the individual who is being evaluated. Finally, meetings may be closed if required to do so by another law or as permitted by the attorney-client privilege. Some added notes on the attorney-client privilege aspect. Closing a meeting for this reason can only be done in narrow circumstances. Public bodies cannot close meetings in order to receive general legal advice or even when there is a mere threat of litigation. Rather, public bodies need to balance considerations of openness and the need for absolute confidentiality before closing a meeting for attorney-client privilege purposes. And the meeting should be closed only when there is a need to protect conversations because litigation appears to be likely or is ongoing. Be sure to note the citations on this slide that provide some excellent analysis if you do have questions about when a public body can close a meeting for the purposes of attorney-client privilege. Okay, we're going to transition into the requirements for remote meetings, specifically sections 13D.015, 13D.02, and 13D.021 allow members of public bodies to attend meetings remotely so long as the applicable conditions are met. A few things to keep in mind with these requirements, though. First, the requirements of these sections apply only when one or more members of the public body are attending the meeting remotely. The requirements do not apply when a public body decides that it will stream a meeting or invite guests to join the meeting remotely. Additionally, there is no requirement for public bodies to broadcast an open meeting to the public, whether it's over the internet or on television. When all members of the public body are attending in person, none of the requirements of these sections are applicable. Finally, the open meeting law defines interactive technology as a device, software program, or other application that allows individuals in different physical locations to see and hear one another. In short, public body members need to be able to both see and hear each other when attending a meeting via interactive technology. So let's review each of these sections. Let's start with section 13D.015, which permits state-level entities to hold meetings by public or interactive technology so long as certain conditions are met. Local public bodies, such as county commissions, city councils, or local school boards, for example, cannot use this section to hold meetings remotely. This section is reserved for state public bodies required to hold open meetings, such as the various state health licensing boards, professional licensing boards, and other public bodies, such as the Public Utilities Commission and Minnesota Racing Commission, among others. The conditions to hold a meeting under 13D.015 include all members of the participating entity must be able to hear all discussion and testimony, regardless of their physical locations. All members of the public who are attending the meeting at the regular location must be able to hear all discussion and all votes of the entity's members. Additionally, members of the public must be able to participate in testimony when applicable. At least one member of the entity must be physically present at the regular meeting location. Finally, all votes must be conducted by roll call. Next, 13D.015 subdivision 4 requires that public bodies must, to the extent practical, allow the public to monitor the meeting remotely. This requirement could be met through providing links to watch the remote meeting via a computer or a personal device, or providing dial-in information for a conference call. Finally, a state public body does need to post a notice on its website that some members may be participating electronically at least 10 days in advance of a regular meeting. If it is a special or an emergency meeting, the public body must provide the electronic participation notice according to the applicable notice requirements under section 13D.04. Okay, let's turn to Minnesota statutes, section 13D.02, which permits public bodies to hold meetings by interactive technology so long as certain conditions are met. Notably, holding meetings by telephone is not one of the options here. And so we're solely talking about meetings by interactive technology for local public bodies. These conditions include all members must be able to hear each other, as well as all discussion or testimony. Members of the public who are at the meeting location must be able to hear all discussion and testimony, as well as be able to hear all votes of the body's members. At least one member of the body must be physically present at the regular meeting location. Votes must be conducted by roll call. Finally, each location where a member of the body is present must be open and accessible to the public. However, there are a couple of exceptions to this requirement. First, the location of the member doesn't need to be open to the public if that particular member has not participated remotely in a 13D.02 meeting from an inaccessible place more than 3 times, and the member is serving in the military and happens to be at a required drill, deployed, or on active duty. Alternatively, the member's location doesn't need to be open to the public if the member has not participated remotely in a 13D.02 meeting from an inaccessible place more than 3 times and has been told by a healthcare professional that they should not be in a public place because of medical or family reasons. This latter exception applies only when a Chapter 12 state of emergency has been declared and it expires 60 days after the emergency ends. Some additional notes here. Any location where a member is attending remotely must be open to the public. Public bodies must provide notice of their regular meeting locations, as well as the locations where any members will be participating remotely. However, the locations of members who are participating remotely due to military service or for the listed medical reasons don't need to be noticed or open to the public. Finally, the meeting minutes must include the names of individuals who attended via interactive technology, as well as the reason the member was attending remotely. One last side note here, the legislature is considering removing that Chapter 12 state of emergency limitation related to members attending remotely due to the advice of a healthcare professional. If you're interested in tracking this bill, it is House File 198 and Senate File 455. Again, House File 198 and Senate File 455. Okay, I imagine many public bodies may still be familiar with the requirements of holding meetings under Minnesota statutes, section 13D.021, and we'll walk through them as a brief refresher. So, under 13D.021, any public body can hold a meeting by telephone or interactive technology so long as the following conditions are met. First, the presiding officer, chief legal counsel, or chief administrative officer for the body must determine that an in-person meeting of members of the public body is not practical or prudent because of a health pandemic or Chapter 12 emergency. Again, this is the threshold requirement for whether your body should hold meetings under this section. In other words, you need to determine whether it is safe for the public body's members to meet in person at a regular meeting location. If a quorum of the body can meet in person, then you should not be meeting under section 13D.021. Second, members of the body must be able to hear each other as well as all discussion or testimony. Next, members of the public who are attending at the regular meeting location must be able to hear all discussion. Also, at least one member, the chief legal counsel or the chief administrative officer of the public body, must be physically present at the regular meeting location. However, both of these requirements are contingent on whether attendance at that regular meeting location is feasible due to the health pandemic or emergency declaration. Finally, all votes must be taken by roll call. Other considerations that you should keep in mind when it comes to holding meetings under section 13D.021 are that public bodies must, to the extent practical, permit the public to monitor meetings electronically from a remote location. Public bodies must still adhere to the applicable notice requirements of section 13D.04, and the notices must include the fact that some members of the public body may be attending remotely, as well as include information about how the public can also attend the meeting remotely. Finally, if your body or entity permitted the public to provide comments at in-person meetings prior to the pandemic, you are obligated to find practical ways that would permit the public to provide comments during remote meetings held under section 13D.021. One last note I want to highlight is Advisory Opinion 21-003. In the opinion, the commissioner discussed a situation in which a school board was using 13D.021 to allow a quorum of members to meet in person, but did not permit members of the public to attend in person. The commissioner found this to be a violation of the open meeting law. Essentially, when more than a quorum of members are attending a meeting in person, then you haven't met that first requirement that an in-person meeting is not feasible. As an added note, there's no mechanism that permits in-person meetings while limiting the public to remote monitoring. Okay, one last slide here on the open meeting law and its interaction with data practices before we turn to the potpourri of questions. Section 13D.015, subdivision 1, states that meetings cannot be closed to discuss not public data. In fact, the law permits public bodies to discuss not public data during an open meeting without liability, so long as the disclosure is related to issues that are within the scope of the public body's authority and is reasonably necessary to conduct its business. Any not public data that are disclosed during an open meeting retain their original classification, but the record of the meeting is public. Advisory Opinion 21-002 discusses this aspect in more detail. One other issue to highlight is Section 13.601, which governs data about applicants for appointment to a public body, as well as correspondence between elected officials and individuals. So that may be a worthwhile section to review. Additionally, government entities will want to consider whether public body members are considered employees for data practices purposes. If the members are considered employees, then the classifications of Section 13.43 would apply. If not employees, then data about the public members would be presumptively public. Data about the public body members would be presumptively public. We suggest that a public body make a clear determination on the record, or the entity have a specific policy in place when it has decided that public body members are employees of an entity for data practices purposes. So that was a very quick overview of the general requirements of the open meeting law. There are also other provisions, such as the sections on social media, as well as on enforcement, that I recommend you take time to review on your own. However, I did want to save some time to discuss various questions we have been seeing related to the law, as well as the questions you may have for us. So let's turn to the potpourri portion of the webinar now, where we'll answer some of the interesting questions that we've seen come up in the past few months. Let's start the questions with one about recording meetings and data requests. A public body reached out to us and said they had received a data request for a video recording of one of its meetings. The question was whether the public body was obligated to provide the recording in response to the request. So the answer to this question is that it depends on whether the recording is of an open meeting or a closed meeting. Let's start with a recording of an open meeting. As an initial point, public bodies are not required to record open meetings. However, as I referenced earlier, Section 13D.05, Subdivision 1C, states that a record of the meeting, regardless of form, shall be public. In Advisory Opinion 21-002, the Commissioner determined that recordings of meetings are considered a record of the meeting. So an audio or video recording of open portions of meetings are public data and must be provided in response to a data request. However, the requirements for closed meetings are slightly different. Section 13D.05, Subdivision 1D, does require public bodies to electronically record a closed meeting unless the meeting is closed for the purposes of attorney-client privilege. These recordings must be maintained for at least 3 years unless the law says otherwise. Additionally, the content of a closed meeting recording will likely be classified as not public data under applicable provisions in the Data Practices Act. For example, data contained in a recording of a closed meeting to evaluate the performance of an individual subject to a public body's authority would likely be classified as private personnel data under Section 13.43 of the Data Practices Act. In short, closed meeting recordings are not typically available to the public unless the law states the recordings must be disclosed at some point in the future. But again, if somebody asks for these recordings, you do need to point to a statutory section that allows you to withhold the data. One last note here, the Data Practices Act does not apply to townships that are located outside of the 7-county metropolitan area. So the only obligation that a non-metro township has when it comes to providing a meeting recording, if any, is under section 13D.05 of the open meeting law. Okay, our next question here. A member of the public wants to live stream our open meetings. Do we need to allow that? First off, the answer isn't exactly clear on this one because the open meeting law is silent on whether members of the public can record or live stream open meetings. So this is an open question. That said, the Attorney General's office issued an opinion in 1972 addressing a situation involving the press, who are members of the public, being able to record the open meetings of a city council. In reviewing constitutional case law, the Attorney General opined that the press could record open meetings so long as the recording process was not disruptive to the meeting's order and proceedings. Of course, live streaming is different than using a tape recorder, but the general principle probably remains the same. In other words, it's likely permissible for members of the public to live stream a meeting if the process of live streaming is not disrupting the proceedings of that meeting. All right, our next question here. A public body needs to discuss not public data during an open meeting, which is permitted under 13D.05 subdivision 1. However, members of the body will be reviewing the underlying data, and the public body is wondering whether it can display the not public data on screens that members of the public are able to see. The short answer here is that the public body shouldn't display any not public data on screens that can be seen by the public. A few important provisions to keep in mind that help guide this analysis. First, the language of section 13D.05 subdivision 1B states that not public data may be discussed during an open meeting without liability, so long as the discussion is pertinent to the body's business. The use of discussed is different than shared or disseminated, which likely means that the data itself should not be shared more broadly beyond a discussion. Additionally, section 13D.05 subdivision 1 states that although public bodies can discuss not public data during a meeting, the underlying data itself retains its original classification. Finally, section 13D.01 subdivision 6 requires public bodies to provide at least one copy of board members' materials in the meeting room. However, a public body is exempt from including any not public data within the meeting packet that is available to the public. Taking these provisions together, it's clear that the public body's obligation to protect the actual not public data itself remains in place, and the body should avoid situations when it might disclose a copy of the data without authorization, such as displaying a copy of the data on a public-facing screen. Really, the public body is limited to discussing the data rather than sharing or disclosing the data. Next, we're going to turn to closed meetings. The first question we have is whether a public body can close a meeting to discuss personnel-related issues in order to protect individuals' privacy. As I noted earlier, the open meeting law does not allow a public body to close a meeting to discuss general personnel issues, such as hiring or appointment decisions. Rather, a public body can only close a meeting when specifically authorized by law, which is discussed in more detail in Advisory Opinion 22-008. Some situations when a public body is able to close a meeting related to specific personnel issues include when there will be a discussion of internal affairs data related to allegations of police officer misconduct, for primary consideration of allegations or charges against an individual subject to the body's authority, and to evaluate the performance of an individual who is subject to the body's authority. If the public body is not addressing one of these types of issues, then it probably cannot close a meeting unless there is another provision that it can point to that permits the meeting to be closed. And, as a final reminder, Public bodies can discuss non-public data, as we just mentioned, including private personnel data, during an open meeting without liability, so long as the matter is within the scope of the public body's authority and is reasonably necessary to conduct business. So the mere fact that private personnel data may be discussed is not enough justification for a public body to close its meeting. All right, another question related to closed meetings. A public body has scheduled a special meeting that will be closed under an applicable provision in section 13D.05. The public body is asking whether the meeting needs to be noticed, even though no one from the public will be able to attend. Yes, a special meeting notice is still required in this situation. Generally, the reason for the notice is so that members of the public body, or excuse me, when the reason for the notice is that members of the public know when a public body is meeting. Additionally, our office suggests that all meetings start in open session, even though it may be immediately closed. Starting an open session allows the public body to meet the requirements of getting a clear statement on the record regarding the grounds that permit it to close its meeting and describing the subject to be discussed, as required by section 13D.01 subdivision 3. Additionally, you may want to review advisory opinion 22-009, where the commissioner discussed a situation where a public body held a special meeting that was closed. It provides some additional guidance on how a public body is limited to the purpose described in the special meeting notice, especially when the purpose describes the justification for closing a meeting. In short, a public body still needs to meet the special meeting notice requirements, even in situations when business will primarily be conducted during a closed session as permitted by the open meeting law. Okay, here's one last question that we did receive from a member of the public. The individual had seen multiple members of a public body having a discussion in an administrative office after a special meeting and was wondering whether this was a violation of the open meeting law. Our answer to this question was that it depends on the number of members participating in the discussion, as well as the context or the content of the discussion. Here are the things to keep in mind on this issue. First, recall that a meeting subject to the open meeting law must meet the quorum rule, which are gatherings of a quorum or more members where they are discussing, deciding, or receiving information that is related to the public body's official business. So, a quorum or more members can gather so long as business is not discussed. If these members had gathered in the office to discuss their disappointment in the outcome of a recent football game, then there would probably not be a violation of the open meeting law. However, if the members were rehashing the discussion that was held during the special meeting, then a violation could be occurring. Additionally, less than a quorum of members can discuss business so long as they do not have the intent to facilitate a decision outside of public view. For example, if 2 members of a 7-member board were in the office discussing official business with a constituent, it would probably not be an open meeting law violation. However, if the 2 board members were using the discussion to plan ways to direct the public body, then went and spoke with other members about this plan to fashion a particular outcome outside of a public meeting, it's possible that serial meetings are occurring in violation of the open meeting law. One last point. Oftentimes, the public perception of these different types of gatherings is the more difficult aspect to manage in these situations. If the gathering of members is not subject to the open meeting law, the public may see what is happening and often assume the open meeting law should apply and raise concerns. So, public bodies should always be mindful regarding member discussions outside of meetings so that there isn't an open meeting law violation, whether it's real or perceived. So those are our questions today. We're going to take a look at some of yours and remember to send them to all panelists so we can make sure to see them. A few reminders as we are answering these questions. The slide deck is available on our website and you can access the recording on our YouTube page in the next day or two or maybe early next week. And then I'll also in a little bit be putting up a poll to let in the polling panel here if you would please fill that out and let us know how we did and what other topics you'd like to see in webinars in the future. I'll give a few minutes for the questions to be answered, but I will be putting that up shortly. And if you don't hear us speaking for a little while, don't worry, your audio is still probably working. We're just reviewing the questions and developing the answers, and so we can provide those to you. So we'll turn to the Q&A now.
Okay, I can get started with our first question. This question says, in our public bodies archives, there are audio-video records of elected officials experiencing fatal medical events while in session. Is there any guidance for potential redaction or content warnings for these meetings if the audio-video is published as part of the official record of such meetings? I'm sorry to hear that. So I'll begin with the open meeting law analysis here and just say, first of all, the open meeting law does not require that public bodies record meetings that are open to the public. There are requirements to record closed meetings, but if this is just a recording of a regular, open meeting where then it's going to depend on why you're maintaining the data. So it sounds like here you're recording the public meetings as part of your official record of these meetings. And so Minnesota Statute 13D05, Subdivision 1C, does state that data discussed at an open meeting retain the data's original classification. However, a record of the meeting, regardless of form, shall be public. So generally speaking, any recordings you have of these public meetings are going to be available for the public under this provision. From a Data Practices Act perspective, in the event that you are recording a meeting but retaining it not because it's a meeting, but for another reason, say a personnel reason or something, then it is possible that classifications under the Data Practices Act will apply. I encourage you to reach out and chat with us if you think that may be the case, and Advisory Opinion 21-002 talks about that analysis as well. So that will apply for public bodies that are also subject to the Data Practices Act. There was an additional question here, is there any guidance for redaction or content warnings? Not for redaction, the recordings will be public under that open meeting law provision if it's a public meeting. For content warnings, you can have a discussion with that person requesting the data and just let them know, about the data that they have requested, but that would not be a basis to withhold any data or recordings from the public requester. Thanks.
Okay, we have another question here. This question asks, for a meeting closed to discuss preliminary allegations against an employee, does the employee in question have the right to attend if they don't opt to have it be an open meeting? So the open meeting law doesn't indicate whether the individual who's subject to discussion at that closed session is entitled to attend. The public body could permit the employee to attend the closed session, but the open meeting law is silent as to whether this is required. At a minimum, the employee needs to have sufficient notice that they are the subject of this meeting and then have the opportunity to ask that it be open to the public.
As we are still answering questions here, I'm about to open the poll. If you could spend just a few minutes filling that out, that would be great. And of course, feel free to recommend other topics that you'd like us to cover in these webinars. We're pretty flexible on these and we like offering them for free. So let us know what topics you're interested in having us discuss.
Okay, for the next question, this question asks, does a meeting have to be noticed if there are 2 members, not a quorum, of a city council, 2 members, not a quorum, of a school board, and 2 members, not a quorum, of a park board and staff? It's a good question. So, under the Moberg definition of a meeting that would require these notice requirements, it really requires a quorum of a public body subject to the open meeting law when they discuss, decide information related to its official business. So if there's not a quorum of those public bodies would not be noticing a meeting at that time. I do want to say I'd probably, have a conversation with you regarding these meetings. Are these regular meetings? Are these individuals, tasked by a different body to discuss particular issues? Because there may be questions if that particular meeting that has all those different individuals from other public bodies is also like a subcommittee for a different public body, in which case there might be a notice requirement. So it might be worth having a discussion. And just a final point, as you're thinking about whether these different bodies require notices, that there's not a quorum here. There's not an obvious quorum here for any kind of public body, but as Casey mentioned, there is this. The courts have said that they will interpret the open meeting law in favor of public access. So, and you want to consider public perception as well. So, if you think this might be perceived as a meeting that members of the public think should be noticed, you want to be transparent regarding these conversations and what's going on. But again, if you have questions about whether a particular meeting is subject, whether a particular public body is subject to the notice requirements, feel free to reach out and we can discuss further.
Okay, so we have another question. In case of inclement weather and a physical quorum is not possible, can a member of the board join the meeting remotely without giving their physical location prior to the meeting? So generally the answer to this would be no. If this is a local public body, they'd likely be meeting pursuant to Minnesota Statute 13D.02, which provides additional notice requirements when somebody is attending via interactive technology. So if interactive technology is used to conduct this meeting, the public body has to provide notice of the regular meeting location and the notice of any location where a member of the public body will be participating remotely via the interactive technology. There are exceptions when somebody's participating remotely because they're in the military, or a limited exception within 60 days of a state of emergency. But generally, otherwise, to meet these notice requirements, you still have to comply with the general notice requirements in 13D.04, which at a minimum requires public bodies to provide at least 3 business days notice when they're changing the location of a meeting. So here, as a best practice, if you do need to change somebody's meeting location or the fact that somebody will be attending via ITV, provide at least 3 days notice to indicate that they'll be attending remotely.
Okay, another question regarding notices. So can the public body or can the public posting requirement be met by posting all needed information on a public website? And sort of a follow-up question to that is, do you still need a paper copy posted on site when providing this notice? So you should still have a paper copy at on the principal bulletin board or the office, sort of following the different types of meeting notice requirements. So if it's just a regular meeting, you need to have a schedule of that kept on file at the primary offices. If it's a special emergency meeting, that should be posted on the bulletin board or the room where the meeting occurs. We do have a lot of public bodies that ask if posting on a website is sufficient, because that might actually be one of the most convenient ways, right, to let the public know that you're having this meeting. And, we encourage posting on the website for those purposes, but under 13D.04, posting on the website would not replace any notice requirements for public bodies. Having said that, if you are a state agency, posting on the website can be one of the methods of notice under 13D.04 subdivision 5, but you would still need that schedule of the regular meetings kept on file. But if you're not a state level public body, you do still need to be posting that schedule or the notice, excuse me, of the meeting, and also notifying any individuals who have also requested notice for any special or emergency meetings. So the website would not replace that.
Okay, so we have a related question. Can you talk more about how a public health emergency under Chapter 12 affects the use of interactive technology under 13D.02? Does Chapter 12 apply to that entire section, or just for the requirements of not disclosing location of interactive participants? 13D.02 is that section that allows local public bodies to have members attend via remote locations, attending via ITV under certain circumstances. When you're within 60 days after the removal of a state of emergency. Subdivision 1B2 states that public body members that have been advised by a healthcare professional against being in a public place for medical reasons do not have to have their location open to the public during that period of time if they're using ITV to attend the meeting. And so generally that would mean that you probably don't have to provide notice of their personal home location, but likely that they are attending via remote location and using ITV because there are also monitoring requirements that allow or permit members of the public to monitor remotely when members of the public body are also attending remotely. Again, this is limited to 60 days from the removal of a state of emergency.
And I'm just going to hop in here one more time because that particular provision is under consideration right now, as I mentioned earlier. There are a couple of bills at the legislature that are reviewing and looking at removing that sort of 60-day requirement or that Chapter 12, limitation to noticing the location of members who are sick and under doctor's note to stay home or stay out of public places because they may be contagious. And so again, those bills, if you're interested, are House File 198 and Senate File 455. And so yeah, House File 198 and Senate File 455. What those bills do is just kind of strike that Chapter 12 language there. And so there wouldn't be that limitation or that limitation on the exception for the Chapter 12 emergency or the subsequent 60 days. And so there is some consideration currently about that.
Thanks, Casey. We have another question. This question is asking about not public data being discussed during an open meeting when the meeting's live telecast, and if a person offering up public comment during the public comment portion of the meeting states a health reason for lack of compliance during a public meeting, and then asks whether the public body needs to close that portion of the meeting or take the matter offline. So generally the open meeting law doesn't address the content of public comments or taking the matter offline. A person making a public comment and revealing their own personal information about themselves is not inherently classified as not public data in the Data Practices Act. If they did reveal some sort of not public data during that public comment session, it's not the public body that was discussing it. That public body discussing not public data provision in the open meeting law is when that public body needs to discuss not public data in order to conduct its business. The fact that not public data are discussed generally does not permit the public body to go into closed session whenever they believe that not public data may come up. Public bodies do have the ability to make their own rules and govern the conduct of their meetings and comment sessions. And so if they feel they need to limit public comments to certain topics, that's up to the public body under the circumstances. But generally, there's not an exception to go into closed session anytime that not public data comes up.
Okay, another question here. So if a public body member has a disability and a medical professional recommends they don't attend a meeting in a place open to the public, can they request a reasonable accommodation that they attend virtually in a private place under the ADA? And does it make a difference if the individual is paid a small fee for their participation in the governing body? So what I'll start off with saying is that the open meeting law doesn't really contemplate reasonable accommodations under the ADA. So as you analyze whether or not a reasonable accommodation is available here, it's really outside the scope of the language of within the open meeting law. So we encourage you to sort of chat with your counsel and see what the best approach is for that reasonable accommodation for you. Just to point again towards 13D, 051 or 13D02, you can take a look and see if those interactive technology meetings would work for this individual. There is kind of a limit to, I believe, 3 times that they can attend via remote technology. So this may not be what works best for this individual, but you can take a look at those provisions and see if they'll work for providing remote access to that individual. And if not, I would speak to your counsel about the reasonable accommodation and see if it will work for your public body.
Okay, we have another question here. Can board members have an executive session meeting to discuss upcoming agendas? This would be a closed session. So generally, anytime a quorum of public body members meet to discuss or transact public business, that would be a meeting that's subject to the open meeting law. And that means that the meeting needs to be noticed and it needs to be open to the public. The public body can't go into closed session without explicit statutory authority to close the meeting. And so if these board members, if a quorum of them are meeting to discuss upcoming agendas, that would likely be a meeting that's subject to the open meeting law. It would need to be noticed and it would need to be open. I'm not aware of any exceptions for discussing upcoming agendas that would permit this meeting to be in closed session. We have another question that says, where can we find the CLE information for this presentation? So the CLE code is on the first slide of the downloadable PowerPoint. Let me see if I can grab that number here for you, though. It is... Oh, Casey, I'm not able to get back to the first page of this PowerPoint. Are you able to provide the CLE number?
Yeah, I'm sorry about that. So it's not in the downloadable version, but I'm happy to give it out here. And if you do have questions or are looking to get a CLE and you're going to grab the number earlier, certainly feel free to email our office. We can provide it to you too. But the event code is 480022. Again, 480022.
Okay, we have another question here. How does the open meeting law address sessions for training and board member development? Example, sessions during which board business will not be discussed. A session on principles of trusteeship. So there is an advisory opinion, and I think Casey mentioned that there's an exception to the open meeting law for training or certain team building exercises. And if public business isn't discussed or transacted at those trainings, certain trainings are exempt from the open meeting law. And so you would just need to ensure as a public body that any discussions that occur are limited to whatever the training is or team building exercises, and there is no discussion of public business at that training.
Okay, we have another question here. For a 17-member commission meeting, is there a quorum if 9 members are present? It's a good question. I don't think we clarified a quorum when we were discussing this, and that Moberg versus Independent School District opinion from the Minnesota Supreme Court did define a quorum as a majority of the voting members. So if there is a 17-member commission and 9 voting members are present, a quorum would be present at that time.
And we are about reaching our time, but one last addition to that last question there. There may be some times where in statute you're enabling legislation, if you're a state public body, that it may define quorum differently, or if you have a different type of public body and there's a specific law that defines quorum differently, I would just add follow that versus the guidance. And so that's a little more applicable there. But that is our time for today. So thanks for sending us your questions and all of your attention. If we didn't get to your question, We will follow up with you. We'll make a copy of the question list, and we can certainly follow up with you and answer those questions for you via email. But do stay tuned for a Gov delivery notice for upcoming workshops and webinars. We will have a law enforcement data workshop on February 23rd, and we'll be scheduling another free webinar soon. If you're not already signed up for our newsletter, I encourage you to do so on our website so that you can receive information on those new webinars and workshops as it's available. Otherwise, thank you for joining us and have a great day.